They thought she was a confused black woman signing paperwork. What they didn't know, she was documenting the end of their careers. Let me use smaller words so you can follow along. The sentence hangs in the air of the glass-walled conference room. 12 floors above Peachtree Street, Atlanta glitters through floor-to-ceiling windows. But inside this room, the temperature has dropped to something arctic. Simone Drayton sits motionless, hands flat on the mahogany table. No tremor, no reaction, just stillness that feels like a held breath before thunder. Preston Holt leans across the table, silver hair catching the fluorescent light, Yale Law diploma gleaming on the wall behind him. His smile carries 31 years of never being questioned by anyone who looks like her. He has chosen his target. He does not know she has spent 2 decades being underestimated by men exactly like him. He does not know what that has taught her. He does not know that the leather journal under her palm contains 43 pages of documentation that will end his career. He sees a confused black woman struggling with estate paperwork. She sees a man signing his own professional death warrant in real time. The intake form sits between them. Simone had read it 3 minutes ago. Upside down. Across the table. A skill learned in rooms where documents were never shared willingly. Client presence as confused regarding basic estate terminology. Recommend simplified documentation. Note added by M. Langston, 9:47 a.m. Preston taps the form with one manicured finger. The property transfer, the lien issue, the filing requirements. Each phrase lands like a slap. These are complex matters. Perhaps if you'd brought someone who could help explain, I understand the terms. Do you? His eyebrows rise. The performance of patience. The theater of condescension. Because your questions suggest otherwise. And frankly, my billing rate doesn't accommodate remedial education. Meredith Langston laughs from the corner, quickly smothered, not quickly enough. Simone's phone rests on the table, face down, screen dark. But if Preston looked closely, which he won't because people like her don't warrant close attention, he would see the faint pulse of light along its edge. Recording app active. File name. Memory test, March 15th. She could end this now. One phone call. One credential. One name that appears in every constitutional law textbook published in the last 15 years. But her mother had taught her patience. And her mother's estate deserved better than a firm that would never see her coming. If you've ever had someone underestimate you because of how you look, hit subscribe, because what happens next will make every dismissal you've ever faced worth watching. 6 weeks earlier, the voicemail had arrived at 7:23 a.m. Simone stood in her Cambridge kitchen, coffee cooling on the counter, spring rain streaking the windows that overlooked Harvard Yard. Her phone glowed with a notification from an Atlanta area code. Ms. Drayton, this is Whitfield and Mercer, attorneys at law. We're reaching out regarding the estate of Lorraine Drayton. There are matters requiring your attention as sole beneficiary. Please contact our offices at your earliest convenience. The voice was professional, clipped, the particular tone of someone leaving a message they've left 100 times before. Routine death, routine paperwork, routine client. Simone replayed it twice. Not for the content, for the subtext. They had called her Ms., not Doctor, not Professor, not the Honorable, just Ms. Drayton, daughter of the deceased, expected to sign where indicated. She could have corrected them, could have let her assistant call back, arrange things through proper channels, invoke the web of professional courtesies that smoothed every interaction in her regular life. Instead, she booked her own flight. Economy, middle seat, and she did not mention what she did for a living. The offices of Whitfield and Mercer occupied the 12th through 15th floors of a glass tower in Buckhead. Simone arrived at 9:53 a.m. for a 10 o'clock appointment, wearing a modest navy blazer she hadn't touched in years, no jewelry except her mother's watch, a leather satchel worn soft from decades of use. The lobby gleamed with the aggressive opulence of firms that needed clients to feel small. Marble floors, abstract art that cost more than most people's houses. a reception desk the size of a boat. The security guard looked up as she approached the elevator bank. Then he stood. Then he stepped directly into her path. "Can I help you?" His name tag read Bryce Callahan. Former military by the posture, current authority complex by the way his hand rested on his belt. "I have an appointment with the Estates Division." "Uh-huh." He didn't move. "ID." Simone produced her driver's license. He studied it. Studied her. Studied the license again. Behind her, a white woman in pearls approached the same elevator bank. He nodded her through without a glance. "Massachusetts license." He said it like an accusation. "I'm visiting from out of state." "Purpose of visit?" "My mother died." That should have ended it. In any normal building, with any normal security guard, the mention of death would trigger automatic sympathy. Passage granted. Condolences murmured. Bryce Callahan looked at her license a third time. "You have anything else? Another form of ID?" "Is there a problem with my driver's license?" "Just being thorough." Simone reached into her satchel. Passport. She carried it out of habit. Too many last-minute international conferences. He examined it with the intensity of a customs agent at a hostile border crossing. Behind them, 2 men in suits entered the lobby. White, expensive shoes. Bryce waved them toward the elevator without breaking eye contact with her passport. "This appointment," he said finally. "Who's it with?" "I wasn't given a specific name. The Estates Division. I received a voicemail." He picked up a desk phone, dialed, murmured something she couldn't hear, waited, murmured again. His expression revealed nothing. 4 minutes passed. Simone counted them. The skill came automatically. Documentation required precision, and precision required measurement. 4 minutes of standing in a lobby while people who looked nothing like her flowed around her without obstruction. "12th floor," he said finally, handing back her documents. "Elevators to your right." He did not apologize for the delay. He did not explain what had required verification. He simply returned to his desk and his newspaper, as if she had already ceased to exist. Simone noted the position of the security cameras as she walked, counted them, filed the information away without conscious thought. 3 visible from the elevator bank, 1 aimed at the reception desk, 1 covering the main entrance, 1 with a slight gap in coverage near the service corridor. The elevator arrived. She stepped inside, pressed 12, and began to build her case. The reception area of the Estates Division smelled like leather and old money. More art on the walls, abstracts that probably cost more than her first car. A receptionist with perfect hair and a smile that didn't reach her eyes. "Drayton," Simone said. 10 a.m. appointment. The receptionist's fingers moved across her keyboard. The smile remained frozen. "Of course. Please have a seat. Someone will be with you shortly." Shortly, in the language of Whitfield and Mercer, meant 47 minutes. Simone sat in a chair designed to look expensive but feel uncomfortable, the kind that kept clients on edge, slightly anxious, ready to agree to things they shouldn't. She watched the reception area with the patience of someone who had spent decades observing systems designed to exclude her. Other clients arrived, were greeted warmly, were ushered immediately to interior offices. A woman in her 60s, white, wearing enough jewelry to fund a small scholarship, called back at 10:08. A young man in a suit that cost more than Simone's monthly rent, called back at 10:15. A couple, white, arguing quietly about something involving a vacation home, called back at 10:23. Simone remained in her uncomfortable chair. At 10:32, a woman in her late 30s emerged from the interior offices. Blonde. Tailored dress. The particular confidence of someone who had never been made to wait for anything in her life. "Ms. Drayton?" Simone stood. "I'm so sorry for the wait. We've just been absolutely slammed this morning." The woman extended her hand. Cool grip. Brief contact. "Meredith Langston. I'll be handling your mother's estate. Please follow me." They walked down a corridor lined with portraits. Senior partners, all of them, stretching back decades. White faces in gilded frames, the genealogy of exclusion presented as tradition. Meredith's office was smaller than the others Simone glimpsed, junior associate territory, despite the senior in her title. Stacks of files covered every surface. A law degree from the University of Georgia hung slightly crooked on the wall. "Please sit." Meredith gestured to a chair across from her cluttered desk. "First, let me say I'm so sorry for your loss, for your sorrow. Losing a mother is never easy." "Thank you." "Now." Meredith opened a folder. Simone could read the label upside down. Drayton, Lorraine. "Your mother passed approximately 3 weeks ago, correct? And you're the sole beneficiary of her estate?" "Correct." "Wonderful. Well, not wonderful that she passed, obviously, but—" Meredith laughed at her own awkwardness. "The paperwork should be straightforward. Single beneficiary, property in Decatur, some financial accounts, standard probate process." She spoke slowly, over-enunciated each word, the particular cadence of someone explaining to a child. "Do you understand what probate means?" "Yes. It's the legal process by which—" "I understand what probate means." Meredith blinked, recalculated, continued anyway. "Well, the property is the main asset. 4-bedroom house in Decatur, been in your family for, let me see." She flipped pages. "Quite some time. Generations, it looks like. Is that correct?" 4 generations. How lovely." The word landed flat. "Now, there will be some paperwork. Quite a lot, actually. Title transfer, tax implications, filing fees. I'll walk you through each document, and you just sign where I indicate. Does that work?" Simone reached into her satchel, removed a leather journal, set it on the desk between them. "I'll be taking notes." Meredith's smile flickered. Just a fraction, just enough to notice. "Of course. Whatever makes you comfortable." She began explaining the estate process, basic information, first-year law school material, but her pace remained slow. Her vocabulary remained simple, and every few sentences she paused to ask, "Does that make sense?" "Yes." "Are you following?" "Yes." "Should I explain the executor role? It's like being in charge of—" "I understand what an executor does." 30 minutes passed. Meredith covered ground that should have taken 5 minutes, stretching each concept thin, pausing for questions Simone didn't need to ask. Finally, she reached the fee schedule. "Now, the firm's rates are quite reasonable for this level of service." She slid a document across the desk. "Estate processing, $4,200. Filing fees, naturally, are additional. And there's a small complexity surcharge, $1,800, just to cover any unexpected issues that might arise." Simone studied the document. The numbers were absurd. Triple what any competent attorney would charge for a straightforward estate. The complexity surcharge had no legal basis and no explanation. "What complexity?" "Well, you never know with estates. Things come up. Liens, claims against the property, family members appearing out of the woodwork." Meredith laughed. "It's really just a precaution, standard practice. The estate is straightforward. Single beneficiary, clear title, no contests. What specific complexity justifies $1,800? Meredith's smile tightened. "Trust me, Ms. Drayton, there's always complexity. That's why you need us." Simone opened her journal, made a note. Small, precise handwriting that Meredith couldn't read from her angle. Fee schedule presented. Complexity surcharge $1,800. No specific justification provided. Potential violation of Georgia rules of professional conduct, Rule 1.5. Unreasonable fees. I'll need to consider the fee structure before signing. Of course. Meredith slid a folder across the desk. Take the documents home. Review them. But don't wait too long. There are filing deadlines, and delays can cause issues with the property. A threat dressed as advice. The particular art of weaponizing process. Simone took the folder, rose from her chair. I'll be in touch. I'm sure you will. Meredith's tone carried something new. Dismissal, perhaps, or the confidence of someone who believed she had already won. Simone walked back through the corridor of portraits, past the reception desk with its frozen smile, into the elevator that smelled faintly of expensive cologne. In her mind, she was already building the timeline. The delays, the condescension, the inflated fees, each item categorized, each violation noted. The doors opened to the lobby. Bryce Callahan looked up from his newspaper. His expression carried the same assessment as before, measuring, dismissing, moving on. She walked past him without acknowledgement. Through the marble lobby, into the Atlanta heat. Behind her, the building gleamed with the particular arrogance of people who had never been held accountable. They would learn. If you're already sensing this firm picked the wrong woman to underestimate, hit that like button, because the receipts she's about to collect will bury them. Chuck. 2 weeks later, Simone returned to Atlanta with a manila folder containing every document Meredith had requested, and several the firm hadn't asked for but might find inconvenient. Original will, notarized, dated, witnessed, death certificate, official copy from Fulton County, property deed, traced back 4 generations of Drayton ownership, tax records, 7 years of filings, all current, all clean, title search, conducted independently by a service that owed no favors to Whitfield and Mercer, and copies of everything, notarized, certified, stored separately from the originals. Because Simone Drayton had survived 2 decades in spaces that tried to erase her by never handing anyone the power to make her disappear. The security guard was different this time, not Bryce. A younger woman who barely glanced at her ID before waving her through. Progress, perhaps, or simply a different shift. Upstairs, the reception area held the same manufactured calm. Simone approached the desk. Drayton, 2 p.m. appointment. The receptionist, different from last time but wearing the same frozen smile, typed efficiently. Ms. Langston is with another client. Please have a seat. 32 minutes this time. Shorter than before. Still longer than anyone else who arrived after her. Meredith emerged eventually, looking harried. Ms. Drayton, perfect timing. Let's get you sorted. They walked back to Meredith's cluttered office. Simone set her manila folder on the desk. The documents you requested. Meredith opened the folder, rifled through the contents with perfunctory attention, stopped at the tax records. Oh, you brought originals. Something in her voice shifted. We actually only needed copies. I should have been clearer. I also have copies. But I understood you needed originals for the filing. Well, yes, eventually. Meredith closed the folder. Let me have Janelle process these and we'll be in touch. She pressed an intercom button. A moment later, a woman appeared in the doorway. Early 30s, natural hair pulled back tight, expression carefully neutral. Janelle, take these documents to filing, Drayton Estate. Janelle took the folder without making eye contact with Simone. Right away. Wait, Simone stood. I need a receipt for the originals. Janelle paused, looked at Meredith. Something passed between them, a communication Simone couldn't read but noted. We don't usually do receipts. Janelle's voice carried the same slow cadence Meredith used. The documents are safe with us. Those are original documents. Some are irreplaceable. I need acknowledgement that they're in your possession. Another look between them. Meredith sighed. Janelle, just write something up. The receipt arrived 5 minutes later, handwritten on a legal pad page. No letterhead, no file number, no notarization. Just a scribbled list and Janelle Crow's signature. Simone studied it. This should reference the file number. Excuse me? Janelle's neutrality cracked slightly. Standard documentation practice. Every transfer of materials should reference the file number for tracking purposes, especially original documents. Meredith's chair creaked as she leaned back. Miss Drayton, are you a lawyer or something? The question landed like a test, an assessment, a way of sorting her into a category that would determine how she was treated. Simone could answer truthfully, could reveal the Harvard faculty ID in her wallet. the SCOTUS credentials in her files, the treatise on civil rights that sat on Meredith's own bookshelf, spine out, never opened. Instead, "I've dealt with paperwork before." She photographed the receipt before handing back the legal pad. The shutter sound was silent. Meredith didn't notice. "We'll be in touch," Meredith said, in a tone that meant, "We'll contact you when we feel like it." Simone walked back to the elevator, pressed the button, waited. The doors opened to reveal Bryce Callahan stepping out from the service corridor. "Oh." He stopped, looked at her satchel. "Visiting again?" "Leaving, actually." "Uh-huh." He didn't move from her path. "You come here a lot." "This is my second visit." "Seems like a lot. Most clients don't come in person so much. They do things by mail. Phone." "I prefer to handle important matters personally." His eyes moved to her satchel, lingered. "What you got in there?" "Personal belongings." "Mind if I take a look?" Simone's pulse remained steady. Years of practice. Decades of encounters exactly like this one. "Am I being detained?" The question landed harder than he expected. His expression flickered, confusion, then irritation. "I'm just asking a question. And I'm just answering. Am I being detained, or am I free to leave?" Another flicker. He was used to people who capitulated, who opened their bags without question, who accepted that his uniform granted him authority over their belongings, their movements, their dignity. "You got something to hide?" "I have a right to privacy. There's a difference." For a moment, the lobby held its breath. Simone could feel the attention of the receptionist, the security cameras, the marble itself, all waiting to see how this would resolve. Bryce stepped aside. "Have a nice day, ma'am." She walked past him without acknowledgement, through the automatic doors, into the Atlanta heat. Behind her, she could feel his eyes tracking her exit, adding her to a mental list, the difficult ones, the ones who didn't comply. She added him to her own list. Obstruction, harassment, documented. The case was building. 1 week passed, then 2. Simone called the firm from her Cambridge office. The line rang 7 times before connecting to voicemail. She left a message. Professional. Inquiring about progress on the estate. No return call. She called again 3 days later. Same voicemail. Different message. Still professional. Still unanswered. On day 12, she tried Meredith's direct line, a number provided on the firm's website, theoretically connecting to the attorney handling her case. "Whitfield and Mercer, this is Janelle." "This is Simone Drayton. I'm trying to reach Meredith Langston regarding my mother's estate." "Ms. Langston is in meetings all day. Can I take a message?" "I've left several messages. None have been returned. I need an update on the filing status." A pause. The rustle of papers. Or perhaps just the pretense of searching. "Let me check on that." "Drayton, you said? I'm seeing your file is still in processing." "It's been nearly 3 weeks." "These things take time, Ms. Drayton. Estates are complicated." There it was again. Complicated. The word weaponized to justify delay. What specifically is causing the delay? "I'd have to look into that. Someone will call you back." "When?" "As soon as possible." The line went dead. Not a goodbye, not a timeline, just silence. Simone set down her phone, looked out her office window at Harvard Yard, where students moved between buildings in the particular rush of spring semester finals. She had published 12 books on civil rights law. She had argued 3 cases before the Supreme Court, 2 of them successfully. She had advised 2 presidents on judicial nominations. And she could not get a return call from a mid-tier Atlanta law firm handling a routine estate. She opened her laptop, pulled up the Georgia State Bar website, searched for Whitfield and Mercer. No disciplinary actions on public record. Clean slate. The firm's reputation unblemished. But reputations only reflected what got reported. And most people who encountered discrimination in legal services, the delays, the inflated bills, The condescension never filed complaints. They assumed it was normal. They blamed themselves for not understanding. They paid the fees and moved on. Simone had spent her career making sure that pattern didn't continue. She opened a new folder on her desktop, named it Whitfield and Mercer Documentation, and began to organize her evidence. The first invoice arrived on day 18. Simone opened it at her kitchen table, morning light streaming through the Cambridge windows. The letterhead was crisp. The numbers were absurd. Initial review and consultation, $2,340. The original estimate had been $800 for this phase. The discrepancy wasn't subtle. It was a dare. She called the firm. Same voicemail. She left a message specifically requesting itemized billing, a breakdown of how 47 hours of billable time had accumulated in fewer than 3 weeks for a straightforward estate. 2 days later, a response arrived. Not itemized billing, just a form letter. Thank you for your inquiry regarding your account. All fees reflect work performed in accordance with our engagement agreement. Payment is due within 30 days to avoid service interruptions. Service interruptions. The threat encoded in bureaucratic language. Simone called again. This time she was transferred, eventually, to Meredith Langston directly. Ms. Drayton. Meredith's voice carried the particular warmth of someone who had been caught. I apologize for the delay in returning your calls. Things have been absolutely hectic. I need an itemized breakdown of the charges. I'm sorry? Georgia Bar Rule 1.5 requires that fees be reasonable and that billing be transparent upon client request. I'm making that request. Formally. Silence on the line. Long enough that Simone could hear Meredith's breathing shift. Careful now. Calculating. Of course. I'll have someone send that over. By when? Within the week. I'll expect it by Friday. Ms. Drayton. The warmth had evaporated. I'm sure you understand that we're a busy firm. We have many clients, many demands on our time. These processes take... I understand billing practices, Simone interrupted. I also understand that failure to provide itemized billing upon request is a violation of professional conduct rules. Friday, Ms. Langston. She hung up before Meredith could respond. The itemized bill arrived Thursday evening. Simone opened the email at 11:47 p.m., knowing it had been sent late deliberately, hoping she wouldn't review it until after close of business Friday. Research, property lien issues, 6.0 hours, $1,680. She cross-referenced the charge against the county records she'd pulled herself. No lien had existed on the Drayton property since 1987, when her grandmother paid off the last of the construction loan. 6 hours of research on something that didn't exist. She added the discrepancy to her documentation file. The case was building. The meeting request arrived 3 days later. Not from Meredith, from Preston Holt. Ms. Drayton, I understand there may have been some communication issues regarding your mother's estate. I'd like to invite you to our offices to discuss the matter personally and ensure we're providing the level of service you deserve. Preston Holt, Partner, Estates and Trusts Division. The name on the door. The man who signed the letterhead. Simone booked another flight to Atlanta. Economy. Middle seat. She did not mention the documentation folder that now contained 43 pages. Preston Holt's office occupied a corner of the 14th floor, with views that stretched to the Atlanta skyline and beyond. Oil paintings on the walls, mahogany furniture polished to a mirror shine, a bookshelf lined with leather-bound legal volumes that looked more decorative than functional. He rose from behind his desk as Simone entered. Silver hair, charcoal suit, the particular smile of a man accustomed to being the most important person in any room. Ms. Drayton. He extended his hand. Firm grip. Eye contact that assessed her in a single sweep. Please sit. I'm so glad you could come in. Simone sat. The chair was more comfortable than the ones in the reception area. A calculated kindness. I understand you have some concerns about our billing practices. He settled back into his own chair, radiating patience. I want you to know, Whitfield and Mercer takes client satisfaction very seriously. If there's been any confusion, I'm here to clear it up. There's no confusion. Simone opened her satchel, removed the itemized bill, set it on his desk. Your firm charged for 6 hours of research on a property lien that doesn't exist. Preston's smile flickered. He picked up the document, scanned it with the particular speed of someone who had already been briefed. Property matters can be complex. There is no lien. I pulled the title search myself. The property has been clear since 1987. He set the paper down. The smile remained, but something behind it shifted. Ms. Drayton, I appreciate your thoroughness, but you may not understand what legal research entails. We are required to verify. Verify what? The county records are public. The search takes 15 minutes. You charged for 6 hours. Preston leaned back, studied her. The assessment in his eyes had changed. She was no longer simply a difficult client. She was a problem to be managed. I've been practicing law for 31 years, he said, his voice carefully measured. I've handled estates worth $50 million, complicated trusts, international properties, matters that would make your mother's estate look like a rounding error. He paused. Let the comparison land. And I'm telling you, there's complexity you're not seeing. There's always complexity. That's why you need professionals. Then show me the documentation. I'm sorry? The research you conducted, the lien you investigated. Show me the documentation. His smile vanished. Ms. Drayton, we don't typically share internal work product with clients. You're billing me for work product. I'm entitled to see what I'm paying for. The silence stretched. Preston's jaw tightened. Behind him, the Atlanta skyline gleamed with indifferent sunlight. Let me be direct, he said finally. Your mother's estate is not complicated. It's not valuable. It's a small property in Decatur and some modest savings. The fees we're charging are more than reasonable for the service we're providing. The fees are triple the industry standard for a straightforward probate. His eyebrows rose. And how would you know industry standards? The question was meant to dismiss, to remind her of her place, to establish, once again, that she was a layperson stepping beyond her understanding. Simone let the silence hold, let him see her not responding to the bait. I've done my research, she said finally. Have you? Not a question, a dismissal. Well, Ms. Drayton, let me explain something. Legal work isn't like shopping for groceries. You don't compare prices and pick the cheapest option. You're paying for expertise, experience, access, and frankly, he gestured to the office around him, the view, the mahogany, the oil paintings. You're paying for quality. I'm paying for work that wasn't done. That's your interpretation. That's the county records. Preston stood. The meeting was over. His patience, never genuine, had reached its limit. I'll have Meredith review the billing with you in more detail. In the meantime, I strongly suggest you reconsider your approach. This firm has represented some of the most prominent families in Georgia. We don't take kindly to accusations. A threat, barely veiled. Simone stood as well. She didn't move toward the door. Mr. Holt, my mother was a school teacher for 42 years. She raised 3 children on a salary that wouldn't cover your monthly dry cleaning bill. The house in Decatur is the only thing she had to leave behind, and your firm is trying to extract every dollar possible from her estate using manufactured complexity and fabricated charges. Preston's face reddened. That's a serious accusation. Yes, it is. She turned toward the door, paused. I'll be in touch. So. She made it halfway to the elevator before Preston's door slammed open behind her. Ms. Drayton. His voice carried down the corridor, sharp, commanding, the tone of a man who had never been walked away from. Simone turned. He stood in his doorway, jacket still buttoned, face still flushed. Meredith had appeared from somewhere, standing behind him, watching. I want to be very clear about something. He walked toward her, each step deliberate. You're making a mistake, a serious mistake. This firm has resources, connections. We've dealt with difficult clients before. If you want to play games, I'm not playing anything. Then you should know the consequences. He stopped 3 feet away, close enough to loom, close enough to intimidate. Your mother's estate will be held in probate indefinitely. Filing delays, administrative complications. By the time we're done, the property taxes will have eaten half the value. Is that what you want? The threat was explicit now, no longer encoded in bureaucratic language. Just raw, professional violence dressed in a charcoal suit. Simone's pulse remained steady. 20 years of hostile depositions, 15 years of testifying before congressional committees, 3 arguments before the Supreme Court, where 9 justices stared down at her with the full weight of constitutional authority. Preston Holt, partner at a mid-tier Atlanta firm, did not register on that scale. Are you threatening to delay my mother's estate as retaliation for questioning your billing? I'm explaining how things work. I understand how things work, Mr. Holt. She reached into her satchel, removed her phone. The recording app was still open from the meeting, time-stamped and running. I've been documenting this conversation since I entered your office, as I've documented every interaction with your firm for the past 6 weeks. His face went pale. That's illegal. Georgia is a one-party consent state for Georgia Code Section 161162, one-party consent for recording. As long as I'm a participant in the conversation, I'm within my rights. She smiled for the first time. Not warm, not friendly. Just the satisfaction of a trap well laid. I'm a participant. Preston's mouth opened. Closed. Opened again. Who the hell are you? A client with good documentation. She turned and walked to the elevator. Pressed the button. Waited. Behind her, she could hear Meredith's urgent whisper. Preston's heavy breathing. The particular silence of people realizing they had made a serious mistake. The elevator arrived. The doors opened. Simone stepped inside. I'll be in touch, she said again. The doors closed on their faces. The lobby was empty when the elevator reached the ground floor. Security desk unmanned. Afternoon sunlight streaming through the glass walls. Simone walked toward the exit, phone still in her hand, recording still active. The automatic doors parted, then stopped. A hand on her shoulder, fingers gripping hard enough to bruise. She spun. Bryce Callahan stood behind her, uniform stretched tight across his chest, face arranged in the particular expression of manufactured authority. I need you to come with me. Simone stepped back, breaking his grip. Remove your hand from my person. There's been a complaint. He moved to block the exit. We need to discuss it. What complaint? That's what we're going to discuss. Another security guard appeared from the corridor, younger, nervous, clearly following orders he didn't understand. They formed a loose barrier between Simone and the door. Am I being detained? I'm asking you to cooperate. I asked a question. Am I being detained, or am I free to leave? Bryce's jaw tightened. Behind him, through the glass doors, Simone could see the parking lot. Her rideshare app waiting on her phone. Freedom, 15 feet away. Look, ma'am, this can be easy or it can be hard. Mr. Holt called down. Said you made threats upstairs. We need to sort this out before you leave the building. I made no threats. I documented a conversation. Your employer threatened to delay my mother's estate as retaliation for questioning fraudulent billing. That's not what he said. I have a recording. Would you like to hear it? The younger guard shifted uncomfortably. Bryce's grip on his belt tightened, not reaching for anything, not yet, but the threat was implicit. You're not leaving until we resolve this. Then you're detaining me. I'm asking you to cooperate. And I'm asking you to clarify my legal status. Simone kept her voice steady, loud enough for any security cameras to pick up, though she suspected they had been conveniently turned off. Am I being detained on suspicion of a crime? Am I being arrested? Or am I being illegally held by private security officers who have no law enforcement authority? Bryce's face reddened. The same flush Preston had worn upstairs. The particular color of men who weren't accustomed to resistance. You're making this harder than it needs to be. You're making this illegal. Unlawful detention is a crime under Georgia Code Section 16521, kidnapping, in the most serious interpretation. If you're not going to arrest me, which you have no authority to do, then you need to let me pass. For a long moment, nobody moved. Then Bryce stepped aside. Get out. Simone walked through the doors, into the parking lot, into the Atlanta heat. Behind her, she heard Bryce mutter something to the younger guard. The words were indistinct, but the tone was clear. This wasn't over. If you're starting to realize this woman isn't who they think she is, hit subscribe, because the receipts she's collecting are about to blow this case wide open. 3 days later, the phone call came. Ms. Drayton, this is Janelle Crow from Whitfield and Mercer. Simone set down her coffee. Outside her Cambridge window, rain streaked the glass. Early evening. Too late for a routine call. Yes? I'm sorry to inform you. The words came slowly, reluctantly. There was an incident with our document processing system. Some files were accidentally destroyed. The pause stretched. Simone waited. What files? Your mother's original documents. The will, the death certificate, the property tax records. They were processed through the wrong queue and shredded. Simone's grip on the phone tightened, but her voice remained steady. When did this happen? This morning. We discovered it about an hour ago. All of them? The originals, yes. We're so sorry. Of course, we can help you obtain replacement copies, but that may take several weeks. Government agencies, you know. Bureaucracy. Several weeks. During which time the estate would remain in limbo. Filing deadlines would pass. Complications would multiply. The complexity they had invented would become real. It was elegant in a terrible way. Destroy the evidence. Create the delay. Blame the victim. I'll be in Atlanta tomorrow, Simone said. That's really not necessary. These things happen. We can handle the replacement process remotely. I'll be there at 9 a.m. She hung up before Janelle could respond. Then she opened her documentation folder, scrolled to the section labeled Backup Copies, Notarized, Certified, stored in a safety deposit box at a bank in Decatur, 2 miles from her mother's house. Because Simone Drayton had learned, a long time ago, never to give anyone the power to make her disappear. She arrived at Whitfield and Mercer at 8:52 a.m. The security desk was staffed by the younger guard from the previous encounter, not Bryce. He waved her through without comment. The reception area held the same manufactured calm, the same frozen smiles, the same other clients flowing through while she stood at the desk. I'm here to see Janelle Crow. The receptionist, new again, or perhaps just interchangeable, typed efficiently. 1 moment. Janelle appeared within minutes. Her expression was carefully arranged, sympathy blended with professional distance, the particular look of someone delivering bad news they had caused. Ms. Drayton, thank you for coming in. I'm so sorry about this situation. Please, let me show you what happened. They walked to a back office. Document processing, according to the sign on the door. Banks of filing cabinets. A shredding machine in the corner, industrial-sized, capable of destroying years of records in minutes. There was a mislabeling issue, Janelle explained. Your file was marked for destruction instead of processing. By the time we caught it, the documents had already been... She gestured toward the shredder. Destroyed. Yes. Simone studied the machine, studied the filing system, studied Janelle's expression for tells. How does a file get mislabeled? Human error, it happens. In a law firm handling sensitive original documents? Janelle's composure cracked slightly. We have protocols. Sometimes they fail. Which employee mislabeled the file? That's an internal matter. I'm a client whose original documents were destroyed. I have a right to know how it happened. The silence stretched. Janelle's eyes moved toward the door, toward escape. I'll have to consult with Ms. Langston about that. Consult now. Another crack. Janelle's hand trembled slightly as she reached for the phone on the wall. She dialed, murmured something, waited. Her face tightened. Ms. Langston is unavailable. She suggests. Simone set her satchel on the nearest desk, opened it, removed a folder. I have notarized copies of everything that was destroyed. Janelle's expression froze. Certified by the Fulton County Clerk's Office. Chain of custody documented since the day I first brought the originals to your firm. Simone laid the folder on the desk between them. Death certificate. Property deed. Tax records. The will, with witnesses who are still living and prepared to testify to its authenticity. She watched Janelle's face cycle through recognition, alarm, and something that might have been fear. I keep copies, Simone said, of everything. The office door opened. Meredith Langston stood in the frame, face flushed, breath slightly elevated. She had rushed from wherever she'd been hiding. Ms. Drayton, thank you for bringing these. She reached for the folder. Simone pulled it back. These stay with me. Of course. We'll just make copies. You've destroyed my originals once. I won't provide you an opportunity to destroy the backups. Meredith's smile tightened to the point of breaking. Ms. Drayton, I understand you're upset, but surely you can see. I see a pattern of behavior that suggests either remarkable incompetence or deliberate misconduct. Simone kept her voice level, clinical, the tone of a professor delivering a failing grade. I see inflated billing, fabricated research charges, weeks of unreturned communications, and now the convenient destruction of original documents that would be difficult to replace. That's an extremely serious accusation. Yes, it is. From the doorway, another figure appeared, larger, more commanding. Preston Holt, summoned by some internal alarm system. What's going on here? Ms. Drayton is. I'm documenting another violation. Simone removed her phone. Destruction of original client documents, failure to maintain proper chain of custody, potential spoliation of evidence relevant to future legal proceedings. Preston's face went red. Put that phone away. I'm within my rights. You're in our offices, our property, our rules. Georgia recording laws apply everywhere, and right now, I'm recording Meredith Langston's admission that my mother's original legal documents were destroyed due to your firm's negligence. He took a step toward her, close, too close, the kind of proximity designed to intimidate. Simone didn't move. You think you're clever, he said, voice low. You think because you can quote a few statutes, you understand how this works, but you don't. You have no idea who you're dealing with. I know exactly who I'm dealing with. I've dealt with men like you my entire career. Your career? He laughed. The sound was ugly, dismissive. What career? Filing paperwork? Managing an office? Something like that. He was close enough now that she could smell his cologne. Close enough that his breath warmed her face. Close enough that if he moved suddenly. He grabbed her wrist, fast, hard, the grip of a man accustomed to controlling spaces and people and situations. Give me that phone. Remove your hand. I said give me the phone. His fingers tightened. Simone's pulse spiked, not fear exactly, but the body's automatic response to threat. Behind her, Meredith hovered. Janelle had backed toward the door. Nobody was going to intervene. You're committing battery. Simone's voice stayed steady. Georgia Code Section 16-523. Intentional physical contact of an offensive nature. There are witnesses. Witnesses who work for me. And a recording that doesn't. His grip loosened slightly. Calculation replacing anger. Your word against mine. My documentation against yours. She twisted her arm, the motion sharp, precise, the kind that created space without escalating. His fingers slipped. She stepped back. The phone remained in her hand. For a moment, nobody moved. The office hummed with fluorescent light and suppressed violence. Then Preston straightened his jacket. Get out of my building. Gladly. She gathered her folder, walked toward the door. Janelle stepped aside. Whether from courtesy or fear, Simone couldn't tell. At the threshold, she paused. Mr. Holt, I'll be filing a complaint with the Georgia State Bar regarding your firm's conduct. Billing fraud, document destruction, and now, physical assault. I suggest you retain your own counsel. She didn't wait for his response. Walk to him. The elevator ride down felt longer than usual. Simone's wrist throbbed where Preston's fingers had dug in. By tomorrow there would be bruises. Evidence. She photographed her arm while the elevator descended. 3 pictures, different angles, time-stamped automatically by her phone. The lobby was empty again. She walked through the automatic doors without stopping, into the parking lot, into her waiting rideshare. Airport, please. The driver nodded, pulled out, said nothing. Simone stared out the window as Atlanta slid past. The skyline, the traffic, the particular rhythm of a city that had never quite decided what it wanted to be. In her lap, her phone buzzed with an incoming text. Unknown number. Atlanta area code. Miss Drayton. We should talk. There are things about Whitfield and Mercer you should know. Things that might help your case. I can't meet openly, but if you're willing, call this number tonight at 9 p.m. Don't mention this to anyone. A friend. Simone read the message twice, then a third time. Someone inside the firm was reaching out. Someone who had access to information she didn't have. Someone who, for reasons she couldn't yet understand, wanted to help. The car merged onto the highway. The airport approached. But tonight, she wouldn't be flying back to Cambridge. Tonight, she would be making a phone call. The motel was the kind of place that didn't ask questions. Cash only. No security cameras in the parking lot. A room that smelled faintly of bleach and someone else's regrets. Simone sat on the bed, phone in hand, waiting for 9 p.m. Outside, Atlanta hummed with evening traffic. Voices from neighboring rooms carried through thin walls. Someone was watching television too loud. Someone else was having an argument. At 8:57, she dialed the number. It rang once, twice, then a click. Ms. Drayton? The voice was female. Distorted somehow, through a filter, or perhaps just held at a distance from the phone. Thank you for calling. Who is this? Someone who's watched what they're doing to you. Someone who's seen them do it before. Before? You're not the first black client they've targeted, not the first estate they've delayed, not the first set of documents they've accidentally destroyed. The words settled into the motel room like stones. How do you know this? Because I work there, and I've been documenting it for over a year. Simone's pulse quickened. A witness, an insider, someone who could corroborate the pattern she'd already begun to see. Why are you telling me this? Because you're the first one who fought back. The others, they paid the inflated bills. They accepted the delays. They didn't ask questions. A pause. The filter on the voice crackled slightly. You asked questions. You kept records. You didn't let them make you invisible. What do you have? Emails, internal memos, billing records that show systematic overcharging for minority clients, document destruction logs that don't match what's reported to the bar. Why haven't you reported this yourself? Because I need this job. Because they'd bury me. Because... The voice cracked, without the filter, for just a moment. Because I don't have what you have. What do I have? The ability to be believed. The words hung in the silence. Simone understood them immediately. The particular arithmetic of credibility. The way some voices carried weight and others were dismissed. The way power protected itself by determining who got to speak. What do you want from me? I want you to take them down, use your complaint, build the case. I'll feed you what I can, but it has to come from you, from someone they can't discredit. And in return, I want to watch them fall. A car passed outside. Headlights swept the curtains. The television next door shifted to a commercial, suddenly louder. How do I contact you? You don't, I contact you. Check your email in 3 days. There'll be a file. Read it carefully. The line went dead. Simone sat in the motel room, phone silent in her hand, processing what she'd just heard. Someone inside Whitfield and Mercer was ready to burn it down, and they'd chosen her to light the match. 3 days later, the email arrived. No sender address displayed, rerouted through enough servers to be effectively anonymous. The subject line was blank. The body contained a single line, the 2019 audit. They buried it. Here's what they didn't want found. Attached, a zip file, encrypted, password protected. A second email arrived 30 seconds later from a different anonymous route. Password, .rg1987. Your mother's initials and the year she bought the house. Simone felt a chill. Whoever this was had done their research. They knew details about her family that weren't public record. She downloaded the file, entered the password, watched the folders unfurl. Internal billing reports from 2017 to 2023. Client demographic data cross-referenced with fee schedules. Statistical analysis showing a consistent pattern. Black clients charged 2.3 times the rate of white clients for comparable services. Documents marked for destruction, 27 instances in the past 4 years, 24 of them involving minority clients. And at the bottom, the 2019 audit, conducted by an external consulting firm. Findings: systematic billing discrepancies, potential violations of professional conduct, recommendations for bar reporting. Action taken: none. The audit had been buried. It had paid for, completed, and then locked away in a server nobody was supposed to access. Until now. Simone read through the files twice, made notes, cross-referenced with her own documentation. The case was no longer about her mother's estate. It was about a pattern of discrimination that stretched back years. Dozens of clients, hundreds of thousands of dollars extracted through manufactured complexity and calculated delay. She picked up her phone, dialed a number she had memorized but never expected to use. Georgia State Bar, Disciplinary Division. I need to file a complaint, Simone said. Formal, documented, and I have evidence of a cover-up. Cox. The bar investigator arrived in Atlanta 2 weeks later. His name was Marcus Webb, early 50s, former prosecutor, the kind of tired that came from years of watching systems resist accountability. They met in a coffee shop. Neutral ground. Ms. Drayton. He shook her hand. Firm grip. Direct eye contact. I've been reviewing your complaint. It's thorough. It's incomplete. How so? Simone opened her satchel, removed a folder, thicker now than when she'd started, over 100 pages of documentation. I've received additional information since filing. Anonymous source inside the firm. Internal documents showing a pattern that goes back at least 6 years. Marcus raised an eyebrow. Anonymous sources complicate things. Authenticity, chain of custody. The documents have metadata, server origins, timestamps. They can be authenticated. He took the folder, flipped through the first few pages. His expression shifted, the particular look of someone encountering evidence more damning than expected. The 2019 audit. He lingered on those pages. How did you get this? Someone inside wanted it found. Someone inside could have planted fabrications. They could have, But the audit was conducted by Morrison and Associates. They're a legitimate consulting firm. You can verify with them directly. Marcus closed the folder, set it on the table between them, studied her. Ms. Drayton, I have to ask, who are you really? The question was the same one Preston had asked. Meredith? Bryce? But Marcus asked it differently, without dismissal, without condescension, with genuine curiosity. A client with good documentation. He smiled, just slightly. In my experience, clients don't compile evidence packages like this. They don't understand metadata authentication. They don't cite Georgia code sections from memory. I've dealt with paperwork before. More than paperwork, I think. The silence held. Outside, Atlanta traffic moved past the coffee shop windows. Inside, two people assessed each other across documentation that could end careers. Mr. Webb, does it matter who I am? Does it change the validity of the evidence? No. He picked up the folder again. But it might change how we approach this. If you have resources I don't know about, connections, expertise, I need to understand what we're working with. She reached into her satchel, removed a second item, set it on the table. A book, leather-bound, gold lettering. Drayton on Civil Rights, a comprehensive treatise. 7th edition. Marcus stared at it. His face cycled through recognition, surprise, and something that might have been awe. You're Professor Drayton? Harvard Law? I'm a client whose mother's estate was held hostage by a corrupt firm. The rest is just context. He picked up the book, turned it over, studied the author photo on the back cover. A younger Simone, but unmistakably the same woman. This book is on my shelf at home. I cited it in 3 cases last year. Then you know I don't make accusations lightly. He set the book down, the folder of evidence, the treatise, the coffee growing cold between them. Ms. Professor Drayton, this changes things. I know. The firm will fight. Hard. They have resources, connections. They'll try to discredit you, discredit the evidence, discredit me for taking the case. I know. And you still want to proceed? Simone thought of her mother's house in Decatur. 4 generations of Drayton women. The roses in the garden, overgrown now but still blooming. The porch where her grandmother had sat, watching the neighborhood change around her, refusing to leave. My mother taught 3rd grade for 42 years. Every day she walked into a classroom and taught children who the system had already decided didn't matter. She never stopped believing they deserved better. She closed the folder. The treatise. I don't stop either. Marcus Webb nodded. The tired lines in his face shifted, not erased, but reorganized. Purpose replacing exhaustion. Then let's build a case they can't bury. The evidence accumulated like water behind a dam. Over the following 3 weeks, Marcus Webb conducted interviews. Former clients, former employees, anyone who had passed through Whitfield and Mercer's estates division and left with stories they'd never told. Simone tracked the patterns from her Cambridge office, organizing data into spreadsheets that would have made her research assistants weep. Names, dates, fee discrepancies, document destruction incidents. Each entry cross-referenced with demographic information, creating a picture that grew more damning with every edition. The anonymous source continued feeding information. Encrypted emails arriving at unpredictable intervals, each containing another piece of the puzzle. Meeting notes from partner conferences, internal communications discussing client management strategies. A memo from 2018 explicitly recommending that high-maintenance clients, defined by criteria that mapped suspiciously onto racial demographics, be assigned to junior associates with instructions to maximize billable hours. On day 16, Marcus called with news. We found 4 more victims. Simone set down her coffee. Outside her window, Harvard Yard buzzed with the particular energy of spring semester's final weeks. Students who had no idea that in a law firm 1,200 miles south, a reckoning was building. 4? Similar pattern. black clients, estate matters, inflated bills, document issues. His voice carried the exhaustion of someone who had stopped being surprised by human cruelty. One of them, a woman named Dorothy Sims, her mother's estate took 3 years to settle, 3 years for a straightforward property transfer. By the time she got the house, the back taxes had accumulated to the point where she had to sell it to cover the debt. Did she file a complaint? She tried. The bar dismissed it for insufficient evidence. A pause. Her original documents were also destroyed, accidentally, according to the firm. The pattern wasn't just discrimination. It was systematic wealth extraction from families who could least afford to lose it. What do we need for the formal hearing? More than we have. The audit is compelling, but Whitfield's lawyers will argue it was never adopted, that it was a preliminary assessment, not a finding. The anonymous source documents are problematic because we can't establish chain of custody. What we need is direct testimony, someone inside the firm willing to go on record. The source won't do that. I know, which means we need to force the issue another way. How? Subpoenas, discovery. Make them turn over documents they don't want to turn over. Look for gaps in what they produce. Gaps tell stories, too. Simone thought about the encrypted files on her computer, the metadata that pointed to server origins within Whitfield and Mercer's network, the timestamps that proved certain documents had been accessed, modified, or deleted at suspicious moments. What if we could prove spoliation, that they destroyed evidence after receiving notice of investigation? That would change everything. Spoliation creates adverse inference, the assumption that whatever was destroyed would have been damaging. It shifts the burden of proof. Then we need to trigger their destruction protocols. How? Simone smiled. The expression held no warmth. We make them panic. Chung. The letter arrived at Whitfield and Mercer 3 days later. Official letterhead, Georgia State Bar seal. Language that read like a scalpel. Notice of formal investigation. Pursuant to Georgia rules of professional conduct, the State Bar of Georgia has initiated a formal investigation into allegations of billing fraud, discriminatory practices, and potential spoliation of evidence concerning the estate's practice of Whitfield and Mercer, LLP. All documents, communications, and electronic records relating to the matters identified in the attached appendix are hereby subject to litigation hold. Destruction, modification, or concealment of relevant materials constitutes obstruction and may result in criminal referral. A list of specific client files subject to preservation requirements is attached herewith. The appendix contained 47 names, every black client who had passed through the estates division in the past 6 years. Simone wasn't on the list. That was deliberate. Her complaint had triggered the investigation, but the investigation had expanded beyond her case. She was now a witness, not just a complainant, and witnesses had different protections than parties. The firm had 72 hours to respond. If you're watching this firm scramble to cover their tracks, hit subscribe, because what they do next will determine whether they survive or burn. Simone returned to Atlanta on day 4. Not to Whitfield and Mercer's offices, to a conference room at the State Bar headquarters, where Marcus Webb had assembled the investigative team. 3 attorneys, 2 forensic accountants, 1 IT specialist who spoke in acronyms Simone didn't recognize, but whose conclusions she understood perfectly. They've been busy, the IT specialist said. Her name was Keisha Monroe, no relation to the Layla Monroe in the files, just coincidence, and she had the particular intensity of someone who found digital trails more honest than human testimony. Since the preservation notice went out, their server logs show unusual activity, mass deletions, archive transfers. Someone's been cleaning house. Can you recover what was deleted? Some of it. They're using standard enterprise software, not military-grade encryption. But they've had 72 hours to work, and whoever's doing this knows what they're doing. She pulled up a screen. Look at this. Email server activity past 3 days. Normal baseline is around 200 transactions per hour during business hours. After your notice arrived, this 1,600 per hour, and most of that activity is concentrated in accounts belonging to, she highlighted 3 names, Preston Holt, Meredith Langston, Raymond Whitfield. The managing partner is involved? Based on server access patterns, he's directing it. Keisha pulled up another screen. This is the audit trail for document modifications. Whitfield's credentials were used to access files he's never touched before. Estates cases from 2018, 2019, 2020. Files that were then moved to an archive folder that, according to their IT policies, gets purged every 90 days. They're trying to run out the clock. They're trying to create plausible deniability. Oh, those files. They were archived months ago and automatically deleted per our retention policy. Except the archive dates are backdated, and I can prove it. Marcus leaned forward. How? Metadata. Every file has embedded information about when it was created, modified, accessed. You can change the visible date stamps, but the system-level metadata is harder to fake. Whoever did this was good, but not good enough. She smiled. The expression was predatory. I've got time-stamped proof that files supposedly archived in January were actually moved 3 days ago. That's not just spoliation. That's obstruction of a bar investigation. The room shifted. The case had just escalated from professional misconduct to potential criminal referral. What do we do with this? Marcus stood, walked to the window. The paw. Atlanta spread out below them, gleaming in the afternoon sun. We have 2 options. We can present this at the disciplinary hearing and let the bar handle it. Sanctions, suspensions, maybe disbarment for the worst offenders. Or we refer to the U.S. Attorney's Office. If this is systematic fraud targeting protected classes, it's not just a bar matter. It's federal civil rights territory. 18 U.S.C. Section 242. Deprivation of rights under color of law. They're not government officials. No. But they're officers of the court. And there's case law, limited, but it exists, suggesting that attorneys acting in official capacities can be held to similar standards. He turned from the window. The question is, what outcome do you want? Simone thought about Dorothy Sims. 3 years to settle her mother's estate. Losing the family home to accumulated taxes. A lifetime of memories erased because a law firm saw her as a target rather than a client. She thought about the anonymous source. Still inside the firm. Still feeding information. Still risking everything because they believed accountability was possible. She thought about her mother's house in Decatur. Still standing. Still hers. Because she had happened to have the resources, the knowledge, the stubborn refusal to be erased that most victims didn't possess. I want them to face consequences, she said finally. Real consequences. Not a slap on the wrist and a promise to do better. But I also want the other victims to have a voice. Whatever path gives them the most justice, that's the path we take. Marcus nodded. Then we do both. Bar hearing for immediate accountability. Federal referral for long-term investigation. Let them fight on 2 fronts. See how well their coordination holds up when they're being squeezed from both directions. The formal interview request arrived at Whitfield and Mercer the following Monday. Not a subpoena, not yet. Just an invitation, phrased in language that made clear declining was not actually an option, for Preston Holt, Meredith Langston, and Raymond Whitfield to appear before the bar's investigative panel for preliminary questioning. Date, 3 weeks out. Location, State Bar Headquarters. Subject, matters relating to estate's practice compliance. The firm's response came within hours. Aggressive, defensive. The particular tone of lawyers who had never been on the receiving end of investigation. Our clients categorically deny any wrongdoing. The allegations are baseless, motivated by a disgruntled former client with a personal vendetta. We will demonstrate that all billing practices conform to industry standards and that document management procedures meet or exceed regulatory requirements. Furthermore, we note with concern the involvement of Professor Simone Drayton in this matter. Professor Drayton's professional credentials create an inherent conflict of interest. as her prominence in civil rights legal scholarship may unduly influence the investigative panel. We respectfully request her recusal from all proceedings. Simone read the response in her Cambridge office. The audacity was almost impressive. They were trying to use her credentials against her, arguing that her expertise made her biased rather than informed. It was a classic defense strategy. When you can't attack the evidence, attack the witness. Marcus called that evening. They're scared. They're attacking. Same thing. The motion to recuse you won't go anywhere. You're a complainant, not an adjudicator. But it tells us their strategy. They're going to try to make this about you, your motives, your credibility. They'll dig into your background looking for anything they can use. They won't find anything. I know, but they'll try anyway. It's what defense lawyers do when the facts aren't on their side. They put the victim on trial. Simone looked out her window. The lights of Harvard Yard twinkled in the gathering dusk. Somewhere in those buildings, her treatise sat on shelves, being studied by students who had no idea their professor was about to become Exhibit A in a case that would test everything she'd written. Let them try, she said. I've been preparing for this my entire career. The 3 weeks passed with the particular tension of a countdown. Simone reviewed her documentation until she could recite it from memory. Dates, amounts, discrepancies, the architecture of fraud laid bare in spreadsheets and timelines. She met with Dorothy Sims and 3 other former clients, victims really, who had agreed to provide testimony. Their stories varied in detail but converged on pattern: condescension, delay, inflated bills, documents that somehow disappeared at crucial moments. Each had believed they were alone. Each had blamed themselves for not understanding the process better. None had known they were targets in a systematic scheme. They made me feel stupid, Dorothy said. 73 years old, retired nurse, hands that had held countless patients now trembling with old anger. Every time I asked a question, they looked at me like I was wasting their time, like I should just sign where they pointed and be grateful they were helping me at all. You weren't stupid, Simone said. You were deliberately confused. There's a difference. My mother worked her whole life for that house, cleaned other people's homes so she could own her own. And I lost it because I trusted the wrong people. The weight of that loss sat in the room like a third presence. Simone had no comfort to offer, no words that could restore what had been taken, only the promise that accountability, however partial, was coming. They're going to ask you hard questions, she told Dorothy and the others. The firm's lawyers will try to make you doubt yourselves, try to make you seem unreliable, confused, angry. I am angry. Good. Use it. But don't let them see it control you. Answer their questions directly. Don't elaborate. Don't apologize. You did nothing wrong. They did. And we're going to prove it. The night before the hearing, Simone's phone buzzed with an encrypted message. They're panicking. Whitfield called an emergency partner meeting this morning. Shouting, accusations. Someone suggested settling with all complainants to make this go away. Preston refused. Said settling would be an admission of guilt. Meredith has been crying in her office for 2 days. She's the weak link. Press her. The hearing tomorrow is critical. Don't let them control the narrative. A friend, Simone, read the message 3 times, then deleted it, as she'd deleted all the others. Tomorrow, she would walk into a room where every person who had dismissed her, demeaned her, grabbed her, threatened her, would finally learn who they had been dealing with. Tomorrow, the mask would come off. She slept well that night, the sleep of someone who had done the preparation and now waited only for the moment of truth. The State Bar hearing room was smaller than Simone had expected. No grand chamber with vaulted ceilings and mahogany benches. Just a conference room on the 4th floor, industrial carpet, fluorescent lights, a long table where 3 panel members sat with notepads and water glasses. The setting was deliberately ordinary, a reminder that professional discipline was administrative, not dramatic. But the tension in the room was anything but ordinary. Preston Holt sat at one end of the witness table, flanked by 2 lawyers from a firm that specialized in defending attorneys accused of misconduct. His silver hair was perfectly styled. His suit was immaculate, but something in his posture had changed since their last encounter. A tightness around the eyes, a rigidity in the shoulders, the posture of a man who had realized too late that he was outmatched. Meredith Langston sat beside him. Her composure had cracked visibly in the weeks since the investigation began. Dark circles under her eyes, a tremor in her hands when she reached for her water glass. The weak link, the anonymous source, had called her. Looking at her now, Simone understood why. Raymond Whitfield occupied the far end of the table. Managing partner, the name on the door. He was older than Simone had expected, early 70s, silver-haired like Preston, but with the particular heaviness of someone who had spent decades building an empire and now watched it threatened. His expression revealed nothing. The perfect mask of a man who had survived by never showing weakness. On the opposite side of the room, Simone sat with Marcus Webb and 2 other bar investigators. Her satchel rested at her feet, the same worn leather bag she'd carried into Whitfield and Mercer's offices 6 weeks ago. Then it had contained her mother's documents. Now it contained the evidence that would end careers. The chief hearing officer cleared her throat. This is a preliminary hearing in the matter of State Bar of Georgia versus Whitfield and Mercer LLP, and individually against respondents Preston Holt, Meredith Langston, and Raymond Whitfield. The purpose of this hearing is to establish whether sufficient evidence exists to proceed to formal disciplinary proceedings. She reviewed the procedural requirements, rights of the respondents, rules of evidence, the standard for probable cause. Simone listened with half attention. She knew the process, had written about it in academic papers, had testified in similar proceedings as an expert witness. But she had never been the complainant before, never sat in this chair, waiting for the moment when documentation transformed into accountability. The bar will present its evidence first, the hearing officer continued. Mr. Webb, you may proceed. Marcus stood, organized his notes, and began to dismantle Whitfield and Mercer, piece by piece. The receipts are about to be read into the record. If you want to see these lawyers face what they've done, hit that like button, because the next hour will change everything. The evidence presentation took 3 hours. Marcus methodically walked through the pattern. Client A charged twice the rate of comparable white clients for identical services. Client B, whose documents were destroyed 2 weeks before a filing deadline. Client C, whose estate remained in probate for 31 months due to administrative complications that existed only in billing records. He introduced the anonymous source documents, carefully authenticated, chain of custody established through forensic analysis of metadata. The 2019 audit appeared on screen, its recommendations highlighted, its burial documented. This audit was commissioned by the firm itself, Marcus said. Morrison and Associates, an independent consulting firm with no connection to any complainant, identified systemic billing discrepancies that disproportionately affected minority clients. Their recommendations were clear: immediate corrective action, voluntary disclosure to the bar, restitution to affected parties. Objection, Preston's lead attorney rose. The audit was preliminary, never adopted by the partnership. Its conclusions were contested internally. The audit was buried. Marcus's voice cut through the objection. I have emails, authenticated, time-stamped, recovered from backup servers, showing that Raymond Whitfield personally ordered all copies removed from accessible storage. This stays in the vault, he wrote. No one discusses it, ever. The email appeared on screen. Whitfield's face, for the first time, showed something other than composure. That communication is privileged. Attorney-client privilege doesn't cover ongoing fraud. Crime fraud exception. Marcus turned to the panel. The pattern here isn't confusion or incompetence. It's deliberate, systematic, and documented by the firm's own internal reviews, which they then concealed from regulatory oversight. He continued. The IT specialist testified about server activity following the preservation notice, the mass deletions, the backdated archives, the digital fingerprints of obstruction. Dorothy Sims took the stand, her voice trembling, but her testimony clear. 3 other victims followed, each adding their thread to the tapestry of misconduct. By the time Marcus reached the final phase of presentation, the room felt different, heavier, the weight of evidence pressing down on everyone present. Finally, Marcus said, I want to address the firm's characterization of the primary complainant in this matter. Simone straightened. In their response to the investigation, Whitfield and Mercer described the complainant as a disgruntled former client with a personal vendetta. They suggested her involvement should disqualify her from participation in proceedings, citing her professional credentials as creating inherent conflict of interest. He paused. Let the silence hold. They were right about one thing. The complainant does have professional credentials that the firm systematically ignored, dismissed, and ultimately used as grounds for attacking her credibility rather than addressing her evidence. He turned to Simone. Professor Drayton, would you please introduce yourself for the record? She stood, walked to the witness seat, settled into the chair with the particular composure of someone who had testified in rooms far more intimidating than this one. My name is Simone Drayton. I am the William Nelson Cromwell Professor of Law at Harvard Law School, where I hold an endowed chair in civil rights jurisprudence. I received my J.D. from Yale Law School, summa cum laude, and served as a law clerk to Justice John Paul Stevens during October term 2003. She paused, watched the faces at the opposite table process what she was saying. I am the author of 17 books on civil rights law, including Drayton on Civil Rights, a comprehensive treatise, now in its 7th edition, which is used as a primary text in law schools across the country, including, I'm told, in the associate training program at Whitfield and Mercer. Meredith's face went white. Preston's jaw tightened. Whitfield's mask cracked, just slightly, around the eyes. I serve on the American Bar Association's Standing Committee on Professional Discipline, though I recused myself from any involvement in this matter for obvious reasons. I have testified as an expert witness in over 40 cases involving attorney misconduct. I have argued 3 cases before the United States Supreme Court, 2 of them successfully. She reached into her satchel, removed a book, set it on the table in front of her. The gold lettering caught the fluorescent light. Drayton on Civil Rights. When I walked into Whitfield and Mercer's offices 6 weeks ago, I was treated as a confused black woman who needed complex legal concepts explained in smaller words. I was made to wait 47 minutes past my appointment time while white clients were served immediately. I was questioned aggressively by security personnel who waved other visitors through without a glance. I was charged 3 times the industry standard for services that were never performed. And when I asked questions that any competent attorney would recognize as entirely appropriate, I was mocked, threatened, and eventually physically assaulted by a senior partner who grabbed my wrist and demanded I surrender my phone. She held up her wrist. The bruises had faded, but photographs of them had been submitted into evidence. I documented every interaction because that is what my career has trained me to do. I kept copies of every document because I have spent 20 years studying how institutions use paperwork to make people disappear. I recorded conversations because I knew, from decades of experience, that my word alone would be dismissed, that I would need irrefutable proof to be believed. Her voice remained steady. No anger, no self-pity, just the clinical precision of an expert witness presenting facts. But here's what matters. I should not have needed these credentials for the firm to treat me with basic professional courtesy. The law does not require an endowed chair for a client to receive honest billing. It does not require Supreme Court experience for an estate to be processed in reasonable time. It does not require academic prominence for a human being to be treated with dignity. She looked directly at Preston Holt. You asked me who I was. You demanded to know what gave me the right to question your practices. The answer is the same thing that gives every client that right. The law. the ethical obligations you swore to uphold when you were admitted to the bar, the basic human decency that should govern every professional relationship, regardless of what the client looks like or how much money they have. She turned back to the panel. I am not here because I am a Harvard professor. I am here because my mother was a school teacher who deserved better than to have her legacy picked apart by people who saw her daughter as an easy mark. I am here because Dorothy Sims and the other victims in this case deserve to know that their trust was betrayed, and that betrayal has consequences. I am here because the legal profession cannot claim to stand for justice while allowing this kind of systematic exploitation to continue unchecked. The room was silent. Completely, absolutely silent. Simone picked up the book, turned it so the spine faced the opposite table. You should have read the author bio, she said. It's right there on the back cover. Show. The defense's response was immediate and desperate. Preston's lead attorney launched into a blistering cross-examination, attacking Simone's motives, her methodology, her decision to conceal her credentials during initial interactions with the firm. Professor Drayton, isn't it true that you deliberately presented yourself as an unsophisticated client in order to manufacture grievances for a lawsuit? No, I presented myself as what I am, a grieving daughter trying to settle her mother's estate. I did not volunteer my professional credentials because clients should not need credentials to receive competent, honest service. But you admit you concealed your identity. I did not conceal anything. I answered every question I was asked. No one at your client's firm asked what I did for a living. They assumed they already knew, based on how I looked. You recorded conversations without informing the participants. Georgia is a one-party consent state. As I explained to Mr. Holt when he demanded I surrender my phone, he was familiar with the law, he simply believed it wouldn't apply to him. The cross-examination continued for another hour, but Simone had spent decades in courtrooms. She knew how to handle hostile questioning, when to elaborate, when to give single-word answers, when to let silence do the work of emphasis. By the time the defense finished, they had landed no significant blows. Their strategy of attacking the victim had backfired. Each aggressive question only highlighted the contrast between Simone's composure and their client's documented misconduct. The hearing officer called a recess at 4:17 p.m. We'll reconvene tomorrow at 9 a.m. for closing statements and panel deliberation. This hearing is adjourned. Simone walked out of the building into Atlanta's late afternoon heat. The sun hung low over the skyline, painting the glass towers orange and gold. Marcus caught up with her on the sidewalk. That was... He searched for the word. That was something. It's not over. No. But the panel's faces during your testimony, they're going to find probable cause. This goes to formal proceedings. What happens then? Formal charges, full evidentiary hearing. The respondents get to present a defense, call witnesses, challenge evidence. It's a longer process, could take 6 months, maybe more. He paused. But based on what I saw in there today, at least one of them is facing suspension, possibly disbarment. And the others? Depends on how well they cooperate, how much they're willing to give up to save themselves. He looked back at the building. My guess? Meredith flips. She's terrified. And she knows things that could implicate Whitfield directly. What about the federal referral? In process. The U.S. Attorney's Office has the file. They're reviewing for potential civil rights violations. Another pause. They're also looking at wire fraud. The billing practices, combined with the interstate communications, your emails, the voicemails, create federal jurisdiction. Wire fraud. Civil rights violations. Suddenly, the stakes had escalated beyond professional discipline to potential criminal prosecution. How long? Federal investigations move slowly. Could be a year before anything happens. Could be longer. Marcus shrugged. But the wheel is turning. Once it starts, it doesn't stop. They stood in silence for a moment. The traffic of Peachtree Street flowed past them, indifferent to the small drama playing out on the sidewalk. Thank you, Simone said finally, for taking this seriously, for believing the evidence. Thank you for building the evidence. Marcus smiled, the first genuine smile she'd seen from him. In my experience, most victims don't fight back. They can't afford to. They don't have the resources or the knowledge. You had both, and you used them. I had help. She thought of the anonymous source, still inside the firm, still feeding information, still invisible. Someone on the inside took enormous risks to make this possible. I know, and I hope someday they can step forward safely. But until then, he extended his hand. Justice proceeds one piece at a time. She shook his hand. Firm grip, direct eye contact, the handshake of allies who had weathered something together. I'll see you tomorrow, she said. 9 a.m. sharp. She watched him walk back toward the bar building, then turn toward her own hotel. The evening stretched ahead, time to review notes, prepare for closing statements, rest for what promised to be another long day. Her phone buzzed. Encrypted message. You did it. They're panicking. Whitfield's lawyer just told him to consider resignation. But be careful. Preston won't go quietly. He has friends, connections, people who owe him favors. Watch your back. A friend. Simone read the message, deleted it, and walked into the Atlanta evening with the particular awareness of someone who knew the fight wasn't over. Chapter 2. The second day of hearings began with a surprise. Meredith Langston's attorney requested a private conference with the panel before proceedings resumed. The request was unusual. Preliminary hearings typically didn't involve sidebar negotiations, but the hearing officer granted it. 30 minutes passed. 40. An hour. Simone sat in the hallway outside the hearing room, watching Preston Holt pace the opposite corridor. His composure had deteriorated overnight. His suit was slightly rumpled, his hair not quite as perfectly styled. He kept checking his phone, typing responses, checking again. Raymond Whitfield sat on a bench near the elevator, perfectly still, expression unreadable. The mask was back in place. Whatever panic had cracked it yesterday had been smoothed over, plastered with the particular calm of someone who had decided how this would end. At 10:23, the conference room door opened. The hearing officer emerged first. Then Marcus Webb, looking grim but satisfied. Then Meredith's attorney, looking like a man who had just negotiated a surrender. We're resuming in 5 minutes, the hearing officer announced. All parties to the hearing room. They filed back in, took their seats. The tension in the room had shifted. Something had changed during that closed-door conference, and everyone except Simone seemed to know what it was. Before we proceed to closing statements, the hearing officer said, I need to address a development. Monsieur Langston's counsel has informed us that his client wishes to make a statement. A statement that, I should note, may have significant implications for other respondents in this matter. Preston's head snapped toward Meredith. His expression cycled through confusion, recognition, and something that looked like betrayal. Meredith. Mr. Holt, please. The hearing officer's voice was sharp. Ms. Langston has the floor. Meredith stood. Her hands trembled, but her voice, when it came, was clear. I want to acknowledge responsibility for my role in the practices described in this investigation. I followed instructions that I knew were wrong. I treated clients in ways that violated my professional obligations. I participated in a system designed to extract maximum fees from vulnerable people while providing minimal service. She paused, looked directly at Simone. Professor Drayton, I owe you an apology. When you walked into our offices, I saw exactly what I was trained to see. A target, not a grieving daughter, not a client deserving of respect, a source of billable hours. I am deeply sorry for how I treated you, and for how I treated every client who came to me expecting competence and honesty and received neither. Preston's face had gone red. She's been coached. This is an attempt to... Mr. Holt, the hearing officer's voice cut through his sputtering. You will have an opportunity to respond. Ms. Langston, please continue. I was following instructions. Meredith's voice strengthened. Specific instructions from senior partners about how to handle certain clients. Instructions about which matters to delay, which files to manage, which documents to prioritize for processing errors. By processing errors, you mean destruction? Yes. And these instructions came from... Meredith's eyes moved to Raymond Whitfield. The managing partner sat motionless, mask firmly in place, but something had shifted behind his eyes. From Mr. Whitfield, directly, and from Mr. Holt, who implemented the system within the estates division. You're lying. Preston was on his feet now. His attorney grabbed his arm, trying to pull him back to his seat. This is a desperate attempt to... I have emails. Meredith's voice didn't waver. Sent from Mr. Holt's account, instructing me which clients to slow walk, using language we all understood to mean delay, overcharge, and eliminate documentation. Those emails are fabricated. They're not. I saved copies, on a personal drive, because I knew eventually someone would ask questions. She turned to the panel. I'll provide everything. Names, dates, instructions, the full scope of what we were doing, and who authorized it. The room erupted, Preston shouting, his attorney trying to contain the damage, Whitfield's lawyer requesting an immediate recess, the hearing officer pounding her gavel, trying to restore order. Through it all, Simone sat quietly, watching the system devour itself. Ciao. The recess lasted 2 hours. When proceedings resumed, the configuration had changed. Meredith now sat on the opposite side of the room from Preston and Whitfield, a physical representation of her break with the firm. Her attorney looked exhausted but relieved. Whatever deal they had negotiated, it was done. Based on the developments of this morning, the hearing officer announced, this panel has determined that sufficient evidence exists to proceed to formal disciplinary proceedings against all 3 respondents. However, the nature and scope of those proceedings will differ. She read from prepared notes. Ms. Langston has entered into a cooperation agreement with the bar. In exchange for full disclosure of her knowledge regarding the practices at issue and her testimony in any subsequent proceedings, the charges against her will be reduced. She will receive a public reprimand, a notation in her permanent bar record, and a requirement to complete ethics remediation. She will not face suspension or disbarment at this time. A public reprimand. For years of misconduct, the math of cooperation, give enough to the prosecution, receive leniency in return. It wasn't justice, not fully, but it was strategy. And strategy sometimes required accepting imperfect outcomes. Mr. Holt will face formal charges of billing fraud, discriminatory practices, and obstruction of a bar investigation. Based on the evidence presented, this panel recommends suspension of his license pending the outcome of formal proceedings. Preston's face went gray. Mr. Whitfield will face formal charges of supervisory misconduct, failure to implement adequate compliance procedures, and potential obstruction related to the 2019 audit concealment. This panel notes that Mr. Whitfield's role appears to have been primarily administrative rather than directly participatory in client interactions, which may affect the ultimate disposition. Administrative rather than directly participatory, the language of institutional protection, even now. Whitfield had kept his hands clean enough that the evidence against him was circumstantial, damning in aggregate, but defensible in individual instances. Formal proceedings will be scheduled within 60 days. All respondents are required to maintain their current contact information with the bar and are prohibited from destroying, altering, or concealing any documents relevant to this matter. She closed her notes. This preliminary hearing is adjourned. Simone found Marcus in the hallway afterward. Whitfield's going to walk. Maybe, maybe not. Marcus gathered his files. The formal proceedings will take months. During that time, we'll have full discovery, access to documents they've been hiding, testimony from Meredith about exactly what instructions came from where. But she said his role was administrative. She said that's how it appears. Appearances can change when you dig deeper. He paused. And there's still the federal referral. The U.S. attorney doesn't operate under the same constraints we do. They have tools, subpoena power, grand jury proceedings that can pierce corporate structures in ways bar investigations can't. So we wait. We wait. We document. We continue building the case. He looked at her. And we celebrate the wins we have. Preston Holt is suspended pending proceedings. Meredith Langston's cooperation will open doors we couldn't open before. The pattern is exposed. The 2019 audit is public. 47 clients now have documentation of what was done to them. Will they be compensated? That's a civil matter. Some will likely file lawsuits. Others may not want to engage further. He shrugged. Justice isn't always complete, but incomplete justice is better than none. Simone thought about Dorothy Sims, the house in Decatur she had lost, the lifetime of memories erased. Is it, though? Marcus didn't have an answer for that. The walls are crumbling around Whitfield and Mercer, but some of the architects may still escape. If you want to see how this ends, and whether the final twist delivers justice or more institutional protection, stay with this story. The conclusion is coming, and it won't be what you expect. The formal disciplinary proceedings against Preston Holt began 4 months later. By then, the landscape had shifted. Meredith Langston had provided over 2,000 pages of internal documents, emails, memos, meeting notes stretching back to 2016. The evidence painted a picture of systematic exploitation that went beyond anything Simone had initially documented. Certain clients were flagged at intake. The criteria weren't written down, but they were understood: race, neighborhood of origin, educational background, perceived sophistication. Flagged clients received different treatment, longer wait times, more aggressive billing, less experienced attorneys, more administrative complications. The system wasn't created by Preston Holt. He had inherited it when he took over the Estates Division in 2014, but he had refined it, optimized it, turned casual discrimination into efficient extraction. The hearing took 3 days. Simone attended each session, sitting in the gallery with Dorothy Sims and other former clients. They watched as Preston's defense crumbled piece by piece, his attorney arguing that he had simply followed industry practices, that the billing patterns were coincidental, that the document destruction was the result of clerical error rather than coordinated policy. None of it held up against Meredith's testimony. "He told me which clients to delay," she said, voice clear, eyes fixed on some middle distance that avoided both Preston's glare and Simone's gaze. Not by name initially, by category, the ones who won't push back, the ones without resources. We all understood what that meant. And when Professor Drayton began pushing back, he panicked, called me into his office, said we needed to manage the situation, that she was asking questions no one else had asked. What did manage mean? Delay, destroy documents, make the process so frustrating she'd give up and go away. And when she didn't give up, he decided to intimidate her, confront her directly, show her that fighting back had consequences. The testimony continued, hour after hour of meticulous detail, each piece adding to a mosaic of deliberate harm. On the 3rd day, the panel delivered its verdict. This panel finds, by clear and convincing evidence, that Respondent Preston Holt engaged in systematic billing fraud, discriminatory practices in client treatment, and obstruction of bar investigation. These violations represent a fundamental betrayal of the professional responsibilities attorneys owe to their clients and the justice system. The hearing officer paused. The room held its breath. Respondent Preston Holt is hereby suspended from the practice of law in the state of Georgia for a period of 18 months. Upon completion of his suspension, he must demonstrate completion of ethics remediation and provide full restitution to affected clients before seeking reinstatement. This suspension is effective immediately. 18 months. Not disbarment, but close. And with the federal investigation still ongoing, criminal charges remained possible. Preston sat frozen in his chair. The mask that had served him for 31 years had finally cracked beyond repair. Chapter Raymond Whitfield's proceedings took another 2 months. The case against him was more complex, layers of delegation and plausible deniability insulating him from direct responsibility. Yes, he had buried the 2019 audit. Yes, he had ordered document purges after the preservation notice. But proving he had personally authorized the discriminatory practices required threading a needle through corporate hierarchy. Meredith's testimony helped. So did the IT forensics showing his account had accessed client files in the days following the investigation's announcement. But the defense argued convincingly that access didn't equal authorization, that Whitfield had been reviewing files as part of his supervisory duties, not coordinating a cover-up. The panel's verdict reflected this ambiguity. This panel finds that respondent Raymond Whitfield failed to implement adequate compliance procedures within the firm he managed, and that this failure contributed to the environment in which the documented misconduct occurred. However, the evidence does not establish, by clear and convincing standard, that Mr. Whitfield personally directed or participated in the discriminatory practices. Simone felt the disappointment settle into her chest, the architect escaping while the builders took the blame. Respondent Raymond Whitfield is hereby issued a public censure and placed under monitored probation for a period of 3 years. During this period, the firm must submit to quarterly audits of billing practices, client demographics, and document management procedures. Failure to comply will result in immediate license suspension. A censure, monitored probation, the equivalent of a stern warning and a promise to check in occasionally. Whitfield nodded at the verdict. The mask never wavered. He had survived, as men like him usually did, protected by the very systems they had corrupted. But outside the hearing room, waiting in the corridor, was a woman in a navy suit who had been observing the proceedings for 3 days without ever speaking. She approached Whitfield as he exited. "Mr. Whitfield? I'm Special Agent Carla Torres, FBI, the U.S. Attorney for the Northern District of Georgia would like to speak with you regarding potential violations of federal civil rights statutes. You're not under arrest at this time, but we strongly recommend you bring your attorney." The mask cracked. Just for a moment. Just enough to see the fear beneath. The federal investigation was no longer theoretical. The weeks that followed brought a cascade of developments. Whitfield and Mercer announced his resignation as managing partner to focus on personal matters, according to the press release. He retained his partnership stake, his corner office, his decades of accumulated wealth. But his name came off the letterhead. His authority evaporated. Partners who had deferred to him for years now avoided his calls. The firm entered what the legal press called managed decline. Clients fled. Associates sought positions elsewhere. The quarterly audits mandated by the bar revealed billing discrepancies in other practice groups. The infection had spread beyond estates. A class action lawsuit emerged. 12 plaintiffs initially, then 23, then 41. Former clients seeking compensation for overcharges, delays, emotional distress. The case was assigned to Judge Miriam Blackstone in the Northern District of Georgia, a judge known for skepticism of corporate defendants and careful attention to civil rights claims. Simone's testimony in the bar proceedings was cited in the complaint. Her treatise was referenced in the legal brief. She had become Exhibit A in a case that had expanded far beyond her mother's estate, and still the anonymous source continued sending messages. The federal investigation is accelerating. They've subpoenaed 10 years of financial records. 2 junior partners have hired separate counsel. There's something else, something I couldn't access before. A payment structure that doesn't appear in normal accounting. Shell company. Offshore transfers. I don't know what it means yet, but the amounts are significant. Be patient. The wheel is still turning. A friend, shell companies. Offshore transfers. The investigation was uncovering layers that went beyond billing fraud, financial structures designed to hide money, evade taxes, or facilitate transactions that couldn't bear scrutiny. Simone forwarded the information to Marcus Webb, stripped of identifying details that might compromise the source. "Where did you get this?" "Does it matter?" He studied her. The tired lines had deepened over the months of investigation. But something else had changed too. A sharpness in his eyes, the look of a hunter who had found larger prey than expected. "No," he said finally. "I suppose it doesn't." 6 months after the bar proceedings concluded, the federal indictments came down. Not against Raymond Whitfield, not yet, but against 2 junior partners and a senior associate charged with wire fraud and conspiracy to deprive citizens of civil rights under color of law. The 18 U.S.C. Section 242 statute that Marcus had mentioned, rarely used against private attorneys, but applicable in cases where lawyers exploit their official court functions. The indictments named unindicted co-conspirators, individuals whose conduct appeared in the evidence, but who faced no charges at this time. Legal observers speculated about who those unnamed figures might be. Simone read the news from her Cambridge office, spring sunlight streaming through the same windows that had witnessed the beginning of this journey nearly a year before. Her phone buzzed. Marcus Webb. "Are you watching?" I saw. "This is just the beginning. The U.S. Attorney's Office isn't done. They're building towards something bigger." "Whitfield?" "I can't say. But the financial investigation is ongoing. And the shell company your source mentioned? It connects to other firms, other cases, a network of practices using similar exploitation methods." A network. Not isolated misconduct, but coordinated corruption spanning multiple institutions. How wide? Too early to tell, but the FBI has assigned a task force. This isn't just about one Atlanta law firm anymore. He paused. "Your case broke it open. Whatever comes next, it started with you refusing to be silenced." She thought about that, about the moment in Preston Holt's office when she could have backed down, accepted the inflated fees, signed where indicated, and walked away. Most people would have. Most people did. "It started with my mother," she said. "She taught me that giving up is the one thing you can't recover from." Smart woman. She was a school teacher in Decatur, made less in a year than Preston Holt charged his clients in a month. Simone looked out her window, watching students cross Harvard Yard, oblivious to the quiet revolution unfolding 1,200 miles south. She would have been proud. The resolution, such as it was, came in pieces. The class action settled 8 months after filing. Whitfield and Mercer, operating now under emergency management appointed by the court, agreed to pay $4.2 million to affected clients. Dorothy Sims received $187,000, enough to help with medical bills and retirement expenses, not enough to restore the house her mother had worked a lifetime to own. "It's not justice," Dorothy said when Simone called to tell her. "But it's something." "It's acknowledgement," Simone replied. They admitted in writing that what they did was wrong. That has value, even when the money doesn't match the harm. Does it? Simone had no answer. Only the recognition that accountability, like justice, came in degrees, and that partial accountability was still better than the silence that had protected Whitfield and Mercer for years. Preston Holt's suspension ended 18 months after it began. He applied for reinstatement, completed his ethics remediation, paid restitution to 12 clients, including Simone herself. The bar granted his request, license restored, practice permitted, reputation forever tarnished. He never returned to Whitfield and Mercer. Instead, he opened a solo practice in a strip mall outside Macon, handling DUI cases and minor civil disputes. The mighty had fallen, though not as far as they deserved. Meredith Langston disappeared from legal practice entirely. Her reprimand remained on her record, making employment at any reputable firm impossible. Last Simone heard, she had moved to Florida and was working as a paralegal, the bitter irony of ending up in the position she had once treated with such contempt. Raymond Whitfield remained a target of the federal investigation. No charges had been filed, but no charges had been declined either. He existed in legal limbo, wealthy enough to hire the best defense attorneys, connected enough to delay proceedings, old enough that time itself might provide the ultimate escape. The anonymous source fell silent after the indictments. Their final message had been brief. "My work here is done. The documents are in the right hands. The investigation continues without me. I'm leaving. New city. New name. New life. Thank you for being the one who didn't give up. Thank you for being someone worth the risk. A friend, Simone, saved that message. Didn't delete it like the others. Kept it in a folder labeled Debts Unpaid, a reminder that justice sometimes depends on people who remain invisible, who take risks without recognition, who trust strangers to complete what they started. 1 year after the initial complaint, Simone returned to Decatur. The house stood exactly as she remembered. Red brick, white trim, roses tangled in the front garden. Her grandmother had planted those roses 60 years ago. Her mother had tended them every spring. Now they grew wild, reaching toward a sun they barely remembered. She parked in the driveway, sat for a moment, listened to the particular silence of a place holding its breath. The estate had transferred cleanly months ago, processed by a small firm Marcus recommended, completed in 11 days, fee $1,200. The contrast with Whitfield and Mercer's 3-month ordeal was almost absurd. She walked up the front path, unlocked the door, stepped inside. The house smelled like memory, furniture covered in white sheets, dust motes dancing in sunlight from windows that needed cleaning. Her mother's things exactly where they had been left, waiting for decisions Simone wasn't ready to make. She moved through the rooms slowly. Kitchen where 3 generations of Drayton women had prepared Sunday dinners. Living room where her grandmother had held court, dispensing wisdom and criticism in equal measure. Bedroom where her mother had spent her final months, surrounded by photographs and the particular peace of someone who had lived fully and feared nothing. In the study, her mother's sanctuary, walls lined with books she had collected over 40 years of teaching, Simone found an envelope. It was addressed to her. Her mother's handwriting, careful and clear despite the illness that had been claiming her strength. To be opened when the time is right. Simone sat in her mother's chair, held the envelope, didn't open it. Not yet, not until she was ready to hear whatever final wisdom her mother had left behind. Outside, the afternoon light shifted. The roses caught the sun, their colors muted but still present, still fighting toward bloom despite the neglect. The house would stand. The family would continue. And the questions, the ones that mattered most, would find their answers in time. 3 weeks later, the anonymous letter arrived. No return address. Postmark, Savannah. Inside, a single sheet of paper, handwritten in precise script. Professor Drayton. You should know this isn't over. The federal investigation has uncovered connections that go beyond Whitfield and Mercer, beyond Atlanta. A network of firms using similar practices, sharing methodologies, coordinating to exploit vulnerable clients across multiple states. Raymond Whitfield was a node, not a leader. The system that created him still exists, still operates, still extracts wealth from communities that can least afford to lose it. The 2019 audit that the firm buried? There were others like it. At other firms, all suppressed, all hidden, all protecting people who have never faced consequences. I've sent what I have to the FBI. But federal investigations move slowly, and powerful people have ways of delaying justice indefinitely. You broke open one part of the network, but the rest remains hidden. Waiting. Continuing. The question is, what will you do now? A different friend, Simone, read the letter 3 times, then set it carefully in her documentation folder, the one that had grown from 43 pages to over 200, the record of a year-long fight that had achieved partial victories while revealing larger battles still to come. A network, multiple firms, coordinated exploitation. The investigation into Whitfield and Mercer had been a single thread. Pulling it had revealed a tapestry of corruption that stretched beyond anything she had imagined when she first walked into that Atlanta office building, a grieving daughter with her mother's documents in a worn leather satchel. She thought about the word network, about what it meant to dismantle systems rather than individuals, about the difference between winning a case and changing a culture. Her phone buzzed. Email from a former student, now working at the Department of Justice Civil Rights Division. Professor, have you seen the task force announcement? Multi-state investigation into billing practices at firms with documented disparities. Your bar testimony is referenced in the formation documents. They're calling it Operation Equitable Access. They want to speak with you. As an expert consultant, not a witness. Different role, different scope. Let me know if you're interested. This could be big. Operation Equitable Access. A federal task force. Expert consultation. The fight that started with her mother's estate had expanded into something larger than any single case could contain. Simone looked out her window. Cambridge in spring. Students celebrating the end of semester. A world that kept turning, regardless of the small victories and ongoing struggles playing out in courtrooms and conference rooms across the country. She thought about what Marcus Webb had said. Justice isn't always complete. Incomplete justice is better than none. She thought about what she had said in response. Is it, though? The question didn't have a clean answer. Maybe it never would. Maybe the work of accountability was like the roses in her mother's garden, requiring constant tending, surviving neglect, but never thriving without attention, blooming imperfectly, but blooming nonetheless. She picked up her phone, typed a response to her former student. I'm interested. Send the details. The morning sun rose over Decatur. The house stood empty, waiting. The roses reached toward light they would find, despite everything, despite neglect and loss and the slow passage of time. In Cambridge, a professor prepared for a new chapter. Not the end of a story, but a widening. The recognition that what had begun as a personal grievance had become something larger, something systemic, something that would require more than one person's documentation to address. In Atlanta, a law firm continued its managed decline. Partners scattered. Associates found other positions. The quarterly audits ground on, revealing more discrepancies, more patterns, more evidence of rot that had spread through the institution's roots. In Savannah, someone who had once worked inside that firm looked at their new life, new name, new job, new city, and hoped that the risks they had taken would matter, that the documents they had shared would reach the right people, that justice, however delayed, would eventually arrive. In Washington, a task force assembled. Attorneys and investigators and data analysts, pulling threads that connected firms across states, building cases that would take years to prosecute. The wheel Marcus Webb had mentioned continued turning, slowly, imperfectly, but turning nonetheless. And in a study in Cambridge, Simone Drayton finally opened her mother's letter. My dearest Simone, if you're reading this, the time has come. Whatever brought you to this moment, whatever fight you're facing, whatever wall they've built to stop you, remember what I taught you. They will underestimate you. Let them. They will dismiss you. Let them. They will assume they've already won. Let them. And then you show them who you are. Not because credentials matter, not because titles protect you, but because you carry something they can never take. The knowledge of who you are, where you came from, and what you're willing to do for what's right. I loved you from the moment I first held you. I am proud of you for every moment since. And whatever comes next, I know you will face it with the same stubborn grace that has defined our family for 4 generations. The house is yours now. The roses are yours. The fight, whatever form it takes, is yours. Tend them well. All my love forever. Mom Simone folded the letter, held it against her heart. Let the tears come finally, after a year of holding them back. Then she dried her eyes, opened her laptop, and began preparing for the work ahead. The story wasn't over. It was just beginning. Epilogue. 1 year later. The congressional hearing room was larger than any courtroom Simone had entered. Marble columns, elevated platform where senators sat in judgment, gallery packed with observers, journalists, cameras capturing every moment for broadcast and posterity. She sat at the witness table, leather satchel at her feet, the same worn bag she had carried into Whitfield and Mercer's offices 3 years before. Beside her sat 3 other expert witnesses, a former federal prosecutor, an economist specializing in wealth inequality, a civil rights attorney who had spent 30 years documenting discrimination in professional services. The hearing was titled, Equitable Access to Legal Services, Examining Patterns of Discrimination and Paths to Reform. It was the culmination of Operation Equitable Access, 2 years of federal investigation, 14 firms indicted, over 200 attorneys facing sanctions, restitution ordered for thousands of affected clients across 12 states. Raymond Whitfield had finally been charged. Wire fraud, conspiracy, tax evasion through the shell company network the anonymous source had identified. His trial was scheduled for the fall. His defense attorneys had filed every motion imaginable, delaying proceedings, but the evidence was overwhelming. Preston Holt had been called to testify. His cooperation agreement, trading information about the network for reduced exposure, had helped build the case against his former mentor. The irony was not lost on anyone. The chair of the committee, Senator Williams from Georgia, gavelled the hearing to order. We are here today to examine a system that has failed too many Americans for too long. The legal profession is supposed to be a pillar of justice. Instead, for some communities, it has been an instrument of extraction. She turned to the witness table. Professor Drayton, you are recognized. Simone leaned toward the microphone. Senator Williams, members of the committee. 3 years ago, I walked into a law firm in Atlanta to settle my mother's estate. What I found was a system designed to exploit people who looked like me, people the firm assumed would be confused, compliant, and ultimately silent. She paused. Let the words settle. I was not confused. I was not compliant, and I refused to be silent. But my refusal was possible only because I had resources most victims don't possess: legal training, documentation skills, and the stubborn belief that accountability was possible. What I've learned since then is that my experience was not unusual. It was not an isolated incident at a single corrupt firm. It was a pattern, a network of practices designed to extract wealth from vulnerable communities under the cover of professional services. She looked at the senators, the cameras, the gallery packed with observers who had waited years for this moment. The question before this committee is not whether discrimination exists in legal services. The evidence has proven that beyond doubt. The question is what we do about it, whether we treat this as a problem to be managed or a crisis to be solved, whether we protect the institutions that enabled this corruption or rebuild them around principles of genuine equity. My mother was a school teacher. She taught children who the system had already decided didn't matter. She never stopped believing they deserved better. I don't stop either. The room was silent. Completely, absolutely silent. Then the questioning began. The hearing lasted 4 days. By the end, the committee had committed to comprehensive reform legislation, enhanced bar oversight, mandatory demographic reporting and billing practices, federal standards for document retention. None of it would be implemented quickly. None of it would solve the underlying problems overnight. The systems that enabled discrimination in legal services had been built over decades. They would not be dismantled in a single congressional session. But the wheel was turning. Faster now, with more momentum, toward a destination that remained unclear but felt for the first time possible. In the hallway outside the hearing room, Marcus Webb found Simone. That was something. It's still not over. No, he smiled. The tired lines were still there, but something else had changed. A lightness that hadn't been present when they first met. But it's something. She thought about that. About all the victories that had accumulated over 3 years of fighting. Preston suspended, then cooperating. Whitfield indicted. The network exposed. The class action settled. Operation Equitable Access launched. Congressional hearings convened. And still, the work continued. Would always continue. Because justice wasn't a destination. It was a practice. A discipline. A choice made daily, in courtrooms and classrooms and conference rooms, by people who refused to accept that the world couldn't be better. "Thank you," she said, "for believing the evidence. Thank you for building it." They shook hands. The handshake of allies who had weathered something together, who would face whatever came next with the same stubborn grace that had brought them this far. Outside the Capitol, Washington glittered in the afternoon sun. The dome rose white against blue sky, a symbol of the democracy that remained imperfect but improvable. Simone walked down the marble steps, leather satchel over her shoulder, toward whatever fight came next. The story wasn't over. It was never over. But for today, for this moment, it was enough. This story carries a truth that extends far beyond courtrooms and legal documents. The systems designed to protect us often fail the people who need protection most. Simone Drayton walked into a law firm as a grieving daughter and was treated as a target, not because of anything she did, but because of how she looked. Her credentials didn't protect her. Her accomplishments didn't shield her. Only her refusal to be silent saved her. The first lesson is this: documentation is power. Every note Simone took, every receipt she photographed, every conversation she recorded became a weapon against those who assumed she would simply disappear. In a world where your word can be dismissed, evidence speaks louder than credentials. The second lesson cuts deeper. You should never need to prove your worth to receive basic dignity. The law firm treated Simone differently not because they knew she was unqualified, but because they assumed it. That assumption, rooted in bias, reinforced by institutional culture, is the real enemy. Credentials should not be required for respect. The third lesson offers hope. One person's courage can crack open systems that seemed unbreakable. Simone's fight exposed a network spanning 12 states. Her refusal to stay silent gave voice to hundreds of victims who had been told their experiences didn't matter. If this story resonated with you, take action. Document your experiences. Support organizations fighting discrimination. Share stories like this one. And remember, every system that seems immovable was built by human hands. Human hands can rebuild it. Subscribe now. The next story of justice might be yours.